Hello, ma'am. How are you?
I'm wonderful. Thank you so much. How are you doing?
Fine, fine. Thank you. So we're supposed to be continuing our last session, that is mediation, and today's our topic is mediation process. So let's
Yes.
begin with the first question. That is, how does the mediation process start, and who does initiate it?
All right. So we've seen from when we spoke last about the basic process of mediation, which actually is when there are two parties who are in dispute with one another, and you have the mediator who comes in as a neutral third party to try and help parties communicate with one another to resolve their dispute. Now, when we're looking at how this process is actually undertaken, typically one of the parties will initiate this process of mediation. So it is one of the parties who will take the first step and approach the other party to say, we are in this situation of conflict or of dispute, and maybe we should try out mediation. Now, this is one method. The other is particularly if there are business relations and contracts, you could have a mediation clause right in the beginning. That means if sometime in the future, if there is a dispute, it will be resolved through mediation. So in that case, of course, when that dispute finally arises, and if it does arise, you know that mediation is going to be the process that will be followed by the parties. Having said this, even when I say that one of the parties actually initiates the process, it is entirely a voluntary process, and therefore both parties need to consent whether they want to enter into a mediation. So, whenever one party initiates, the other has to be agreeable to enter into a mediation. So, that is the first primary requirement of the process. Once the parties agree to mediate, now we are taking a situation wherein both parties have agreed to mediation, then they will select a mediator. Again, if this is a pre-clause in an agreement, it is possible that there is some provision that the parties make themselves to either have already selected a mediator or they lay down a process by which a mediator can be selected. Ideally, a mediator is selected by both parties and they do this with consensus. So that is as far as how you choose the mediator. In case there is no sort of arrival at a consensus and each party wants somebody else to mediate, in those cases, of course, if it's an institutional mediation, the institution can help you out. But if it's a private mediation and you're doing it entirely by yourself, there are even instances when people have actually approached the courts and the courts have intervened to help them come to a consensus or help them find that mediator. So once that process is done, of course, having said that, I would like to reiterate the ideal situation is that both parties themselves choose the mediator because that will ensure that the process moves on freely. It's really a matter of trust and faith that the parties show in the mediator, and it's a very, very important aspect for the mediation to really run smoothly. So once that is done, a session of mediation or the first session will be scheduled. Uh, there are generally something what we call as pre-mediation submissions, wherein basically the mediator gets briefed about what the case is really about. In general, it's a very, very light briefing where the mediator sort of gets to meet the parties and very basically understand what the area of dispute really is about. This can be done in various ways. It can either be with a meeting with the parties themselves, where they talk about the case. It can also be that some documents are submitted to the mediator by which the mediator gets a brief. Now, this is only and purely for understanding. At no uh, time should there be any kind of influence that is created in the mind of the mediator at this point. So the mediator needs to be a little careful at this time to not build any prejudices. So you're not listening only to one party and getting prejudiced, but it's a session that is designed only for the mediator to be able to have a very basic understanding of what the issue that uh, is really coming up for the resolution. Once this is done, this is where uh, the actual technical process of mediation commences. So, where you have all the parties that have a meeting, which is also known as the first session of mediation, and it's primarily an introductory session. Now, you can have it in you know in the real sense, in sense of a physical meeting where parties come together at a time and place which is convenient for everyone. Nowadays, also we have the concept of online mediations. So, in that sense, it can also happen online. In this first meeting, and it's a very important and crucial part of mediation, is where you actually set the tones. So the mediator will start with, introducing themselves to the parties and talking a little bit about what is the kind of work they do. Also, creating a rapport and making the parties comfortable so that they are able to, establish that communication and open up those channels for free talking. They will also encourage the parties at this point of time to cooperate. In the event they have any ground rules, they will make a mention of the ground rules. In online sessions, for example, one of the things that we generally do is that parties will not be allowed to speak out of turn and kind of scream over each other, because in this format of how we carry out sessions, it becomes easier because everyone can speak. When you're sitting in person, it's slightly more coordinated in that sense. So we set the ground rules right in the beginning, that you will not interrupt when somebody else is speaking, for example, or you will raise a hand. Everyone is always given an opportunity. It's never a question of not being heard. But so that you are able to maintain the decorum, some ground rules may be set. So in the same way, even in a physical meeting, for example, not using abusive language. It's a very simple, it sounds very simple, but it is something that is very important, that when you address the parties, you must speak respectfully. You will be given an opportunity to say everything you want, whether it is directly to the party or whether it is then in a separate session with the mediator. But you must maintain the decorum of the session. So that this way you can have certain ground rules. Also, in the event that the sessions are timed, so whether you are having an hour-long session, to inform the parties that this session is going to go on for 1 hour. So we will end it after that. And then, of course, sometimes even if it's scheduled for 1 hour, with the consent of all parties involved, including the mediator, you may want to stretch it for some time. But that's only if all the parties are consenting to it. There are other times when you have day-long mediations where you're scheduling it for the entire day. So depending upon what you are looking at, those will come in the form of your ground rules, which you may want to be setting up for the party. So this is one part of it. Now, apart from this, you will then also have the introductory remarks of the mediator, where the mediator will explain the process of mediation to the parties. Though the parties have come in for mediation, you are expecting them to have understood that process. It is extremely important that these are streamlined and put down during that meeting. So, explaining the process, talking about the neutrality of the mediator, talking about the confidentiality of the process, talking about how the process will actually be carried on, explaining how the sessions will be taken up, when you would have a private session, for example. So, all these aspects, once clarified and cleared right in the beginning, makes the process much smoother for the parties to go ahead, and that there are no, technical or procedural roadblocks that you hit once the sessions start. Then Once the introductory statement of the mediator is concerned, it's formally called as the opening statement. We then have the parties that make their statements. Now, when we look at this, this is again a very, very important aspect. All parties are present. Each party is given that opportunity to be able to present their side of the case, their version of it, how they are looking at that issue. At this particular point of time, so they're allowed to make a statement. As a part of the process, the mediator will listen to everything the party has to say without interrupting them. So they will be given enough time and space to be able to say what they have to. One on and off for clarification, for the purpose of uh, understanding that you have understood them correctly, some reflections. So that is a part of the process. Once the parties finish their statement, you will have a brief summary that is given by the mediator. This is basically only so that the parties also know that the mediator has understood them correctly. It's a very important part of communication. A has said something to B, and A means something when he says that something to B. Has B understood it in the same context? So that is again the job of the mediator, to be able to understand what is it that the parties are trying to tell them. So that is what happens. After this, there is a stage what we call as information gathering. Now, information gathering is not necessarily for actual facts because they may have already been placed. It can also happen through documents or other things that parties produce. Yes, if there are things that are needed to be understood, this is a good time to raise those questions. But also, it's the time where the mediator actually understands where the parties are coming from. When you're looking at basically the emotions that are, or the undercurrents of how that dispute has arisen. This is an extremely important stage and needs to be tackled very sensitively. So you don't like tell the parties, okay, now we are going to go into information gathering state and I will try to assess your emotional sort of state of mind. It happens just through the process. So, when you're talking about statement of problems and information gathering, it's just like a casual conversation that the mediator's having with the intention of just being able to understand, not to be able to judge. You are not trying at any point of time to say, what is this person saying? Oh, they are so unreasonable. No, no, how can this be? The mediator has just sort of taking in that information and basically just providing an empathetic ear to the parties, collecting facts, making notes, very important, but also feeling the pulse of the situation. So that is one of the things that is done. Once this is completed, you also have the identifying of the problem. What is the actual issue? What is the crux that we now need to discuss? Now, this can be one issue, it can be several issues. So those are identified, post which the mediator will use a little bit of their discretion and experience to then choose which issues should be taken up first. So there could be many issues. Some of them the mediator feels closer to settlement, or parties are more agreeable because they are aligned. So those issues come up first, and then slowly you go to the slightly more complicated ones where there seems to be a lot more disaligned. Because if you're going to take that issue, for example, right in the beginning, you will not even be able to resolve the ones that the parties are very close to resolve. So that is again where a little bit of discretion comes in. Following which you actually go into the negotiation stage where the parties are actually now saying what is it that they're expecting from the other, what is it that they want. So this is again a very, very interesting part of the process where there is bargaining and there is generating of the options that happens mainly through the parties, but entirely guided by the mediator. So the process is controlled by the mediator. The outcomes is controlled by the parties. So this is how the basic process actually goes on. Once the negotiation stage uh, is completed, parties may arrive at a settlement. In that case, you move ahead for the settlement agreement and then eventually close the mediation. In the event they don't arrive at a settlement, that you realize at the end of the session that what the parties are looking for is completely, different, and that no way there can be an interjection. In that case, you will close the mediation as well. But that is how the stages of the process of mediation actually works.
So while explaining all this, I come across with a few terms, uh, but I have some questions on that account. That is the nature of disputes. Does it affect mediation process or something? The how it can be conducted. It's the nature of dispute.
Yes. Now, one of the most important aspects of this process is that the process is actually queued. Now, the basics we have seen. These are the stages of what you need to do. Now, the actual process that is followed in terms of, for example, when will you introduce something? How will you speak to the parties? Will you take them together or will you invite them for what you call as a caucus? Now, these are all entirely related and subjective to the nature of the dispute. There will be some disputes which will be completely commercial in nature, for example. The discussions also will happen more or less on those lines. There will be other type of cases where there will be a lot of undercurrents that play or come into play, and you need to be slightly more sensitive when you're dealing with those matters. Personal family matters, for example, they will come in with a lot of emotion, definitely much more than probably a bank dispute will have. So you will have to keep that in mind, and that's a part of how the process of mediation works. So the mediator at all times needs to understand the sensitivity of the situation, the vulnerability of the parties, and respect that. Also, one must be able to understand that there will be a certain power dynamic that goes around. Sometimes parties try to intimidate the other, or there will be one party that is more powerful. So those processes also need to be looked at very carefully. There needs to be complete alertness when the mediator is in that session to be able to pick up these points. So, you need to be more and more sort of be in the present moment and be very, very attentive to that process to pick up these signals, which we call as, body language, or something that is not only spoken in words, but all the other aspects as well. So you pick it up accordingly, and that's how disputes get treated. The process as such, the ones that we've discussed, the steps, that is the standard process you will follow for all types of disputes, whether it is family, whether it is commercial, whether it is property, whether it is a divorce case, whatever it is. The process in terms of the steps that are basically followed will remain the same. How you treat each case, that is where the differences will arise, because there can be a very simple case, one transaction issue that comes from mediation. There can be extremely complicated cases with many complicated transactions which also come into disputes. So obviously there will be a difference in the way you handle these cases, but yes, by and far, if you're looking at the process, it will be the same.
Okay. So while explaining all this, you use that caucus. So my next question is about that. What is a caucus in mediation, and when does the mediator use it?
All right. So a caucus is basically a private session between the parties and the mediator. So in a general mediation session, so when we have, for example, the first session, all the parties are present. So everything that is discussed uh, is open for everyone to hear and have access to. So when the parties first discuss the issues, they're talking in the presence of the other party. Now, sometimes the parties are not very comfortable in sharing certain, say, facts uh, or certain aspects of the case in front of the other party at that point of time. So in those cases, they would prefer to discuss it only with the mediator and share that information only with the mediator. Sometimes the mediator feels that, there is, say, for example, a situation which is leading to an impasse. That means, where parties are getting stuck on their points. So how will you sort of, diffuse that tension? So you will say, okay, let me speak to one party individually in a private session where the other party does not or is not privy to that conversation. Now, what happens in that caucus? One, it allows the parties to be more free. And we see this actually in a lot of cases where, say, for example, I'm giving very basic examples. You're trying to settle a dispute for a number. So there is 1 lakh rupees which is contended, and that's what they want. Now, there will be an amount that they're actually willing to settle at, but they don't want to say this in the presence of the opposite party, because then you say, if I'm willing to settle for 50,000, even if they were to pay me 1 lakh, now they will not be saying that I am willing or showing interest in settling at 50,000. So the mediator will take them separately and understand. It's not like, say, oh, okay, what are you willing to settle? Through that conversation, try to understand what are they actually looking for. Explore the possibilities कि अगर यहाँ case मान लीजिए नहीं चला, if the case does not work here, what are your aspects? So we call it the Vatna and the Batna. Worst possible solution, or worst possible scenario, and the best possible scenario. So you explore all of that. Somewhere in that, the party says, I'm claiming 1 lakh, but even if I recover 50,000, that is fantastic. But don't tell the other party. I don't want them to. That is where confidentiality is ensured. This conversation sometimes is not possible when all parties are present. So that's where the caucus comes in. Not every case needs a caucus, but wherever the mediator feels it is necessary, he or they will invite the parties for a caucus. Sometimes the parties ask for it. So they may say, oh, I want to share some information, but I'm not comfortable sharing it with everyone. Can I have a privacy? But one of the things that the mediator here needs to also ensure is that when you are doing that private session, the other party shouldn't feel that you're being partial or that you're supporting only this side. So as a matter of practice, generally, if one party is taken into a caucus, as a general rule, after that session is over, there will be a caucus or a private session that is held with the other party as well, just to understand their perspective. But important to note that what is discussed in these private meetings cannot be shared with the other side unless and until the mediator has expressed permission to be able to share that. So it ensures like the next level of confidentiality for you, where you're willing to share it with the mediator because you trust, by then that rapport has been built. And you are very sure that if you share that information with the mediator, it will not be misused and definitely not be used against you. So that's where the idea of the caucus actually comes.
Yes, so it is the relationship between the client and mediator is privileged.
Yes,
So no one's supposed to be breach that trust.
yes, absolutely.
Okay, and it is vice versa. Means mediator, if feels sometime that she needs to have a caucus or separate meeting with one party, one and one, then he or she can initiate, or sometimes party himself or herself demand for the separate meeting. So
Yes,
it is vice versa.
yes, absolutely. So sometimes the mediator feels the need or the necessity. This is generally happens when, supposing there's a discussion that is going on and you find that you're reaching a roadblock or it's getting very heavy. the issues are not very easy to discuss any longer. The parties are becoming more and more rigid. Immediately, the mediator will break into a caucus. It releases the tension. It's much easier to diffuse that tension. Also, sometimes the parties want to vent. There is a lot of anger and things they want to talk about. So if they speak to the other party, it
Can blast something
there can be this
like
emotions that come to the
uh,
surface, which you don't want at a particular point
more
of time.
often happens
Especially,
that.
yes. So the mediator can take the party away and say, please, you know, tell me how you feel. So they will vent. So they have released that, it's like a pressure cooker. You are just allowing the pressure to be released. After that, when you open, there is going to be much more harmony. I'm not necessarily saying that everything is going to be okay. They are not going to a counselor. They are coming to a mediator. But it helps in diffusing that tension. So in those cases also, it works fantastically well. Supposing also in situations where the mediator feels that the parties need to really just slightly rethink their approach. So you take them into a caucus, and here you're not telling them to rethink. You're just exploring that possibility through some, you know, mindful questioning. What will happen when you do this? What is it that you are really looking for? Just explorative questions that can help the party understand that maybe they need to really keep slightly more of an open mind, or that this is leading to a roadblock. And maybe if you just bend the route a little bit, everything can be okay. You're not influencing the parties in any way. I mean, I have to sort of reiterate this, and no amount of repeating it is enough. I feel the mediator does not at any given point of time either ask the parties to do something, tell them what they need to do, or even influence them. That is not the role of the mediator. But yes, if there is some area where the party is ignorant, the mediator must make the party aware that this is maybe what they need to look at. For example, if there is a law that the parties are unaware of, it can be brought to light that are you aware of this law? You don't necessarily give them your opinion on the law, but maybe they can speak to their lawyers or read up on it and understand what are the implications. So, and that is best done in a caucus. Also, uh, sometimes on some rare occasions, you can have parties that are very, very unrealistic in terms of their demands or even that. So to have that open conversation, you don't want to tell a party in a common meeting, in a joint meeting, that I think you are unreasonable. You can't do that, right? Because then it's definitely completely not something that the mediator is expected to do. So you have them in a caucus where you can, again, you are not going to tell the party that I think you're unreasonable, but that aspect can actually be explored with rigor. Okay, so these are some of the aspects that we actually look at and cover when we need to speak about caucus. So that's basically what happens, or when you enter into a.
Okay, so my third question is what happens if one party refuses to participate in caucus?
Mhm. Okay, so like I said right in the beginning, when the mediator, has the opening statement, they will explain to the parties that maybe if a need arises, we will be having a caucus, and that information, can be shared. Now, generally, you will not really find a party objecting to be called
Participate
into
in.
a caucus themselves.
Right.
They will probably only have an objection when, the other party is meeting with the mediator. And it's quite common. They say, oh, you spent 1 hour with me, but you spent 1.5 hours with the other party. So you are favoring the other party. So this is where the role of the mediator and the mediator portraying neutrality comes into picture. And when I say portray, I don't mean you're putting up a facade of being neutral and being biased from within. But really, once you have that intention set, I think it's a lot to do with that vibe passing on to the parties. So once they are clear about why you have a caucus, and that is it is a completely a safe process, that you're not like cooking up some kind of a conspiracy with the mediator when you go into that caucus. Once the parties understand this, there's really no reason why they wouldn't agree to it. So again, if at all a party is objecting, I think explaining to the parties as to why that session is necessary, how it will help in the process, and that at no point of time it's going to be something that is going to be used against that party, which is not a part of the caucus that they are objecting. So once that clarification comes, there is no reason why the party should really need to say, like, I don't want you to do this. So that's again where, again, I think the comfort that the mediator puts the parties at comes into play.
Okay, so the caucus, I believe not supposed to be same day with both the parties, or it is same day or it's at different days. Means today I'm having session with this party A, and tomorrow or day after tomorrow having the session with party B. So something like that. How it goes?
Okay. So generally, when we look at mediation, it depends on case to case basis. Now, sometimes the parties may themselves agree. Now, cases, like I said, can stretch from being very simple and basic single issue matters to much more complicated with multi layers at different dimensions. Now, each case needs to be taken up differently. Sometimes parties agree that we will mediate for one day. So they will fix a day and say we start in the morning and we end at 5:30 p.m. or 6 p.m. Continuously, the sessions will go on. I think it's a single day mediation. If you don't arrive at a settlement by the end of the day, the mediation will be wound up. So in those cases, of course, you will have the caucus at the same time. But again, it depends case to case and what the mediator feels necessary. Sometimes you have extracted certain information from the party in that caucus. They may need more time to reflect upon it and want to come back to you, say, with either a proposal or a statement or some clarification. So that time must be given to them before you go into a caucus with the other party. At other times, if the need is such where you don't have to wait, you can immediately do it back to back. It's very common actually in online mediations that parties come in and everything is virtual, like how you and I are having this discussion. So everyone will be present in the meeting room, and then the mediator will say, okay, we need to have this private session, so I will just have this party, come into another meeting. So they will have the breakout room and they will have the session there. Both parties come back. Sometimes part of that discussion is shared with the other party. Once that is done, then you say, okay, now maybe I should speak to the other party. So the whole process happens sometimes within a span of 1 hour. And sometimes it happens over a period of, say, a week or sometimes even more than that. So it entirely depends on the case, the complexity of the case, the sensitivity of that meeting, and what is actually discussed. So to pinpoint and say, no, this is a timeline is very difficult. Just like in mediations, you can't really put a timeline. It depends entirely on how the case goes on and what is the nature of the dispute. In the same way, even for a caucus, whether you are going to have it on the same day for both parties, what should be the time would depend upon the case and the situation at that particular point of time. So these are all discretionary decisions that the mediator will actually take, depending on the issue at hand.
So it is largely the nature and magnitude of dispute that decide or help to decide what to do and how it will
Yes,
go.
yes,
Okay.
yes.
Okay.
So
So
that, and also the parties, if they have already said, this is our timeline. If the parties have come into mediation and said that we will mediate this matter for 1 month, and if it doesn't get resolved within a month, then that's the end of it. Then we will respect that as well, and it will go according to that. So it's one, the nature of the dispute, the severity of the dispute, and also if there is any such specific request that the party has for completion in a certain number of days or hours or time, whatever is set.
okay. So the next question is participation in mediation mandatory for both parties or can one party refuse? This is something weird kind of question, but yes.
It's actually something that is fundamental to the process of mediation. Mediation is a voluntary process. And when I say voluntary, it continues to remain voluntary throughout the process. Here, I would like to draw a slight difference from with mediation and arbitration. You enter into an agreement to mediate and say that in the event a dispute arises, we will mediate this matter. At the time when the dispute finally arises, you are in no mood of having these talks and speaking to the other party and mediating. So you say, no, I don't want to mediate. Perfectly all right. You can withdraw from the mediation at any time, before the mediation begins, after the mediation begins as well. At any given point of time, if you feel this is not going the correct way, I don't want to participate in this. You have the freedom to be able to withdraw from the mediation. You will be in the mediation only and only till the time you are there voluntarily. When you're comparing it, for example, to arbitration, if you have entered an arbitration agreement and the agreement is valid on all legal grounds, you will not be able to say, no, now I have changed my mood. You are bound by that
Agreement.
clause, yes, clause or that agreement to arbitrate. Mediation, the nature of the resolution process itself is such that it is going to work only if the parties are there willing. If the parties are not willing, they don't want to participate, you can't. The beauty of the process is when two people really want to resolve their disputes and they're willing to come together and have that conversation. Rest everything, the process is taken care of by the mediator. But the willingness to come into that process has to be that of the parties. If they don't come in with it, there is no point in mediating. Because eventually you are deciding for yourselves what is the solution to the problem. Nobody is telling you the solution. You are curating your own solutions. So if you're not doing that voluntarily, it's it doesn't make sense. So very, very, very important question that you've asked me. Mediations are absolutely voluntary. And yes, if at any given point of time you feel that the process is not working, or there's one party that is sort of intimidating, or there's a power imbalance, you can choose to withdraw from, or whatever other reason it may be, you can choose to withdraw from the mediation.
So it is entirely free will process,
Absolutely.
not convinced or something like influenced by anything, any by
No,
environment, something
no,
on
not
any
at all.
ground.
Not at all. Having said that, in the event it is a court annexed mediation. So generally, when the courts have sent the parties to mediate, ideally at least one attempt needs to be made. So they will have the session, and At least one attempt generally needs to be made. So you can't, when you go back to the court, generally the court would ask you why, that why did you not participate? So some reasonable ground you must have at that point of time if the court chooses to question that, we've sent you for mediation. Why did you not choose to participate in the process? At least one session you could have gone, at least understood what the process is. So if you say there, I don't want. So that is the only time. But even there, you can't be forced to do anything because then you are taking away the process itself. But generally, because the courts, are exploring the possibility of arriving at that settlement, they may choose to sort of say, why did you not even participate? But other than that, no, it is an entirely voluntary
So,
process.
so even court's duty only to suggest whether party is accept or not. That is up to them.
Yes, yes. Now, court annexed mediations or pre-litigation mediations, what is happening is, as a matter of process, the first thing you do is send the matter for mediation. Now, parties don't want to participate, they don't want to settle, it's completely all right. There will be a failure report that is filed, and then the matters will come back to court. So, there is no compulsion for you to participate in that process at any given point of time. The new act also has made it very clear that the process has to be voluntary. So it's now, in black and white that mediation as a process has to be voluntary.
Yes, because voluntarily something defining the free consent. Because law differentiates between consent and free consent. Consent may be influenced by something, whatever it is, but free consent, it's not influenced by anything. That is totally, you have the privilege whether to say yes or no. Right,
Absolutely,
right.
absolutely.
So the next question that I have, can both parties speak freely, or are there rules on how discussions are conducted?
Okay. So now there could be certain rules on how the discussions are conducted. So when you say freely, yes, all parties are given an opportunity to be able to, state their case, to be able to put every point that they want to put across. There's no doubt about it. To be heard is a very, very important right, and that is available to parties in mediation as well. However, if, to put a little bit of decorum, there may be some ground rules that are established. I spoke about it in the beginning as well. So, supposing we are in an online session, for example, you can't say parties speaking freely, matlab everyone is going to speak at the same time and nobody is going to understand what is happening. Now, that may not be allowed. However, you will always be given an opportunity to speak. For example, one of the very important uh, unwritten rules in mediation is that when one person is speaking, another will not interrupt. So, if as a party, for example, I'm laying my case, I'm giving my point of view. This is how I felt in this situation. When I am speaking, you can't say, no, 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 you are not correct. It didn't happen like this, it happened like this. No. When that party has that right, they will be allowed to speak. So interruptions will not be allowed and entertained.
So it is not debatable. Means one party, if you're
No,
speaking, then he or she
no.
should be given time.
Yes. And now when we say debatable, it's not as if you can't say, no, no, this is not how it is. You don't have to accept what another is saying.
Means
But
interruption is not
mediation,
allowed.
yes. So generally, interrupting somebody when they speak, so you allow them to be able to complete what